Good morning, you're Travis Shoemaker.
Notice how the judge immediately asks Shoemaker to speak up. That's not just courtroom formality. It sets the tone. Judges want absolute clarity because every word in these hearings carries legal weight.
Speak up, please.
Yes, ma'am.
And Mr. Shoemaker is currently on probation for the offense of injury to a child. That was a 5-year sentence that was probated for 5 years. There was a motion to revoke that probation filed, and we were here previously. Mr. Shoemaker pled true to counts 1 through 9, which include
Failing community service, skipping treatment, even committing new crimes while on probation. This is a probation officer's nightmare checklist. And when you're already on thin ice, 1 slip is bad, but 9, that's a legal avalanche.
The exception of 7, Judge. It was 1 through 6.
Sorry, you're
8
correct.
and 9.
Thank you. 1 through 6, and then 8 and 9. Just for the record, those include failing to report, failing to do community service, failing to do intensive outpatient treatment, failing to complete the battering intervention program, committing the new offense of domestic violence and false imprisonment in 2023 in San Francisco County, California. Has everyone had an opportunity to review that updated pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections, Ms. Holmes?
None from the defense, Your Honor.
Mr.
Not
Hoffpower?
for the state, Your Honor.
And this was just an open plea, correct? Was there an agreement?
It wasn't an agreement, Your Honor. It was unagreed.
That's what I thought. Okay, Ms. Holmes, you may proceed.
Yes, Your Honor. I've met with Mr. Shoemaker in regards to his violations with probation.
Here comes a defensive strategy, mental health. This is often a last lifeline in revocation cases. But courts are skeptical if the defendant ignored treatment opportunities before. Think of it like asking for a 3rd extension on an assignment you never started.
Issue is absconding and leaving the area in which he at some point had to be extradited from California. Mr. Shoemaker explained the reasoning why he was there, stating that he did contact probation or to let them know that he was needing medical treatment because he was not getting the appropriate treatments locally, and so he decided to go elsewhere, and that's how he ended up in California. I think he does have family out there as well. One of the biggest issues, Judge, in my meetings with Mr. Shoemaker is mental health. It is my understanding that he was extended so that he could participate in some mental health treatment. I do feel that he does need to continue to have some type of mental health treatment. He is asking to be continued on probation so that he can get the appropriate treatment. In addition, maybe the court could consider the cognitive track of ISF as a means of helping Mr. Shoemaker get back on track, as well as if he does have that opportunity to continue to have the GPS monitoring, because we do know that the concern is him being a flight risk. And so I've explained to him, and he would be in agreement that if the court gave him that opportunity so that he could get his mental health back on track and to try to complete probation, that the GPS monitor is appropriate. I've also explained to him, because he had made a statement.
Catch that? The defendant asked about going to Hawaii while on probation. Imagine telling a judge, yes, I skipped probation and got arrested, but can I move to paradise? That's the kind of request that makes judges lose patience.
And in regards to wanting to go to Hawaii, I personally told him that's not happening. And he then stated that he is willing to remain in Jefferson County and would seek help or additional aid so that he could have the appropriate housing to remain in Jefferson County, unless he is given some type of approval to travel. But Your Honor, Mr. Shoemaker is asking that the court give him another chance to get his probation back on track and to get the assistance of mental health treatment.
So, and real quick, Mr. Hoffpower, I probably can...
You understand. You want me to...
Well, I just want to make sure, I'm looking back at the original pre-sentence report, and none of these issues are new issues. The mental health issues, any drug, that was all addressed in that original report, and the supervision plan included.
The judge isn't buying it. She points out that all these treatment options were available from day one. Translation: you had your chance and wasted it. Courts love consistency. If you only ask for help when facing prison, it screams desperation, not rehabilitation.
The requirement and the order that you enter and successfully and follow any services that's through Spindletop. And so you were given all of those opportunities from the beginning. So asking for them now, I mean, that was already done. And it's not just like you left, I don't know what this health issue is that you think they can do better in California, but you went to California and obviously didn't get better because you committed the new offenses of domestic violence that, I mean, appear pretty serious. Mr. Hoffpower?
Your Honor, and I want to make sure that the court, and I want to take judicial notice of the updated pre-sentence, but it's included in there is that he's gone to California twice and that has been extradited. He went the first time and was brought back, and in 11/30 of 2023, he was extradited back, and then when the court allowed him an extension, it went from a deferred to a straight probation. Mm-hmm. That's when the mental health stuff was applied. He didn't comply and actually was caught in California again.
You're right.
Without, he looks like for maybe a month he may have reported.
This is critical. Shoemaker was extradited twice from California. That means law enforcement had to physically bring him back across state lines. Judges hate that. It's expensive, it's defiant, and it shows he was running instead of reforming.
He absconds every time.
Twice. So, I mean, at the original pre-sentence report, when he first got on probation, I said, let's help you out. That's what you needed with services. Then you left, and sometimes I look back at what I let people do, and I wonder what I was thinking. Because you went to California, came back, said, I need mental health treatment again, and I said, okay, and now it's the third time you're saying that after we've had to go get you in California. Is there anything else, Ms. Ruiz, that's not in that updated report that you'd like to add? So, Mr. Shoemaker, anything else, Ms. Holmes? At this time, I'm going to find that you entered your pleas of true, again, to counts 1 through 6 and 8 and 9 freely and voluntarily. Find this counts true. Find sufficient evidence to revoke your...
And there it is. The hammer drops. Probation revoked. 5 years in prison. Remember, revocation hearings aren't about proving innocence. They're about proving compliance. Once you rack up this many violations, the outcome is almost inevitable.
Probation, and at this time revoke your probation, sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This is not a plea agreement. You have some limited rights to appeal. You can talk to Ms. Holmes about that. I'm handing you that admonishment. Ms. Holmes, if you'll get signatures on that and then get the bottom copy. I'm also going to hand you, Mr. Shoemaker, let's see, I probably did this back in 2022. When you were initially placed on probation, I'm not sure if I did that back then when we started, but because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that written admonishment I provide you to make sure you understand that law, okay? And once you sign that, we'll get you a copy of the certification, and then you can go back with the bailiff. Thank you, and thank you, Mr. Ruiz. Good morning, sir. You're Terry Rose.
And just like that, we shift to a murder case. Notice how fast the docket moves? In 1 hour, a judge might revoke probation, hear a murder update, and take a plea. This is the assembly line of justice.
And in cause number 24, DCCR 1369, Mr. Rose is charged with first-degree felony offensive murder. And Mr. Roundtree, what is the announcement? Mr. Nichols, where are y'all?
Your Honor, I tendered to Mr. Roundtree today in court updated discovery.
Okay.
That had come in. It was pretty voluminous, and we put it on a big thumb drive form and gave that to him today.
Do you anticipate anything else coming?
I do not, Your Honor.
Okay.
And I haven't had a chance to talk to Mr. Nichols. I did briefly go through what he tendered this morning, and there may still be some outstanding discovery, but I can get with him and send him an email what I believe may be missing.
Okay.
but I don't want to represent that to the court. for
Sure.
But
Until you can have a
just
chance.
Based on what I reviewed this morning.
So realistically, for you to go through that, to get some other things involved if you need, what I'd like to do is maybe just a 60-day reset instead of a 30-day. That gives you time to go through everything, make any requests to Mr. Nichols. If there's something you need to go out and try to find, get that. And then I'll review the motion and get what you need to hopefully get a announcement maybe at that next court date.
Sounds good, Your Honor.
Okay.
That's fine with me, Your Honor.
Okay, perfect.
Thank you.
Thank you, Ms. Rose. You can go back with the bailiff. All right, sir, are you Christopher Wade? And will your client waive the formal reading of the indictment?
He does, Your Honor.
Mr. Wade, in cause number 24, DCCR 0264, the state is elected to proceed on count one only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from December 29th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wade is not competent?
There's none.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the
8 years for evading arrest with vehicle. Yep, running from the cops in Texas is no joke. Many states treat it lightly, but Texas sees it as life-threatening to officers and the public. Lesson here: high-speed chases don't end well.
Texas Department of Corrections. You will receive that credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read that written admonishment I provide you to see what devices qualify as a firearm. And if you have any questions about how long that lasts or anything about that, you can talk to Mr. Samuel, all right? All right, good luck to you, sir. Thank you, Mr. Samuel.
Thank you.
Thank you, Your Honor.
Good morning, sir. Are you Brandon Dodd? And Mr. Dodd, in cause number 24, DCCR 2418, you're charged with the first-degree felony offense of murder, and that is from October 14th of 2024. Your indictment alleges that you were previously convicted of aggravated robbery February 22nd of 2005. And what that means is that if, I'm sorry. Yes, sir.
The state has also filed a notice of habitual offender. We've alleged an additional felony offense. Electronically filed and served it on Mr. Reynolds
I've got it.
as well.
I've got it right here. So in addition, Mr. Dodd, the state has filed the appropriate motion that alleges that there, in addition to that aggravated robbery, you were also convicted of attempted Hobbs Act robbery in the United States Eastern District of Texas, Beaumont Division, October 16th of 2019. What that means is that if you are found guilty in the murder case and those 2 prior cases are true, then you would be considered a habitual offender, which means your minimum punishment is...
And now, the high-stakes case: a murder defendant with prior aggravated robbery and federal robbery attempts. That makes him a habitual offender, which legally boosts his minimum sentence to 25 years to life. Talk about walking into court with the deck stacked against you.
25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here on the tablet that you've signed with Mr. Reynolds. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 35-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial and are found guilty and what your options are. Do you understand all of that? And Mr. Coleman, is there any other information or discovery that you anticipate that you don't have?
No, Your Honor, and for the record, I'd like to point out that the 35-year offer was a today-only offer. The original offer was higher.
So I want to make sure you understand, Mr. Dodd, that after today, that 35-year offer will not be accepted by the court. So if you're not guilty, go to trial, that's fine. If you change your mind later and you want to enter a plea of guilty, it would either be to something different than that, or it would be open to the court unless there is some new evidence that Mr. Coleman and Mr. Reynolds weren't aware of today. Do you understand? And do you want to reject that offer and have your case set for trial? All right, and Mr. Reynolds, you've got everything. And
Well, Judge, there's a co-defendant in this case, and of course, I have not seen the co-defendant file, and there may be things that are inculpatory to the co-defendant that are exculpatory to my client. So I would like to be able to review that before I announce it ready.
And we
Okay.
had that discussion, and I'm happy to make that discovery available to Mr. Reynolds.
okay, so I will go ahead and set it on the trial docket. If something about that information that you get once that's turned over to you changes the status of the case, just let Mr. Coleman know, let us know. We can make whatever change if there's any issues with regard to offers or negotiations based on that.
Yes, ma'am.
Okay, all right, you can go back with the bailiff. Good morning, are you Anthony Domingo? Yes. And Mr. Domingo was previously in court, entered pleas of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon and the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in each of those cases. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Judge. Yes.
Are there any additions or corrections?
Nothing to finish.
All right, Mr. Lewis, you may proceed.
Judge, with Mr. Domingo, there was a situation, of course, where he had not been out of custody long at the time when he picked up this case, these two cases here. And when he was released from custody from TDC, he had made several strides as far as trying to get stable, as far as maybe finding somewhere to live, stable job, doing what he needs to do. Unfortunately, you know, some of his decisions as far as who he was involved with at the time did not help matters. He also, what you see from the PSI, that there was some drug use that was going on. And from talking with him, I think a lot of that was self-medicating from a lot of the things he dealt with while he was in TDC until after. He lost several family members during that time period, and I believe he even came home to family members that was ill and lost them shortly after. And we believe that community supervision would have the structure of things, of vehicles that he would need to be able to address those issues, address any anger issues that would allow him to not be in this situation again. I think his attitude, which is clear from his additional statement that he gave in regards to how he feels about the situation he's put himself in, as far as wanting to move forward and be productive. I think even probation and their recommendations as far as, you know, allowing the court to know that there are things that are available that could help him to not be in the situation again. And that's what we're asking for, Judge, is that he's given that opportunity. Like I said, in that short time, he did make, you know, a lot of strides. And I believe that going back to TDC at this point would be very counterproductive to his future that he still has out there for him. He's still young. He still, you know, will have a life there afterwards. And he, as well as Mr. Domingo, would like to address the court as well.
Go ahead, sir.
Well, Miss, it's like this. I just got done doing 10 years before, 6 months before I got locked up. And I wasn't doing nothing besides really going to work and taking care of my son and helping my aunt out. That's what I say with trying to get myself good. Yeah. Basically, Miss, like I just feel like, you know, I don't really deserve no time, like, cause the thing is, like, I mean, you gonna do what you want to do, Miss, but my thing is, like, I'm not a bad person. I don't get into stuff, you know. My only thing is going to work and prospering and helping my family prosper and being there for my child. you know, and he was staying with me before this happened. Since I've been home, he's been staying with me, you know, because I've been out of his life since he was 1 year old. And I just want to be able to at least finish.
Was it your kid or another kid that was in the house that day?
It was my child.
It was his son.
Okay, so I have no words. You barricaded, you were out of prison. You'd served 10 years.
Yes, ma'am.
You grew up, more mature. You have an opportunity at freedom.
Yes, ma'am.
You say you're not a bad person and you were doing things great, but you got out, you started using drugs again. You barricaded yourself inside a home with a gun with your...
This moment is jaw-dropping. The defendant claims he's not a bad person, yet was holed up in a house with a gun and his child inside. The judge isn't buying the sugarcoating. Viewers, what do you think? Second chance or too many chances already blown?
11-year-old so that the SWAT team had to come out?
I didn't barricade
But you don't deserve anything. How does that even make sense?
Now, in this situation, it's critical.
It is.
It's very critical.
It's very critical. You're right.
Like the paperwork from the police report is true, but it's not all true. Because I didn't barricade myself in the house. They could have came in at any time.
Okay, so but you were inside the house with a gun. You didn't put something up against the door and barricade
I
it.
did not do that.
Right. Okay, but still, you're inside the house with the gun with your kids. So we're not going to play semantics here and word games about what did and didn't happen. They don't know what they're walking into. They know that they probably received a call.
Saying that somebody had a gun.
Yeah.
And I understand that.
And that part's true, right?
Yes, ma'am.
So they don't know what they're coming up on.
Yes, ma'am.
Mr. Smith?
Judge, the Ring camera that was associated with this also showed that he was brandishing the weapon, threatening to kill the paramour, and he's had, I believe, several chances at probation. He's never been able to successfully complete probation. He was on probation from 2011 until he finally got revoked on the other case in 2014. After that, he went to prison, was in prison for 10 years, and didn't make it 6 months before he committed these crimes. The chances of him actually being able to make probation are very small, I believe, and the fact that this could have been a lot worse had police not been calm and not just gone in the house. It could have been bad for her, for the boy, and for the defendant here. He has no education. He's probably limited to labor-type jobs only, and he's demonstrated an unwillingness to follow the law, to make himself a useful member of society. He was using drugs, and a fairly substantial list of drugs. He was on alcohol, cannabis, Xanax, ecstasy, and codeine.
Codeine.
After having just gotten out of prison, and possessed a firearm and threatened people with the firearm.
Was there some time when you got out of prison that you had to go to a halfway house?
No, ma'am.
Because you had to do all your time?
I did all my time. Yes.
You did every bit of it.
Yes, ma'am.
You know what that tells me? That tells me that you didn't act right while you were in prison.
For the
Because,
most part, I didn't.
most people make parole.
Not
You
saying
know?
For the most part, I didn't.
You didn't?
I'm not gonna lie. about
Okay.
Nothing, man. I was young. Like going through TDC, it's hard to.
I have no idea. I'm sure it's hard. I have no idea.
And Judge, if I may,
Yeah.
I think some of the things I was talking about as far as the things that's available through probation, Judge, will help with his emotional stability, because a lot of that was, like I said, the things he dealt with while he was there, and what he came home to. Like I said, he made strides and everything as far as to try to get himself stable before he's taking care of himself. I think, he needs to spend more time on himself before he get into relationships and things like that that could draw him into situations like this. for his, not having that emotional stability.
All right, anything else? Mr. Domingo, I think you've had all the opportunities. The fact that you got out and immediately started using drugs, all the drugs,
Can I speak music?
Yes.
When I filled out my PSI, I filled out my PSI for all the drugs that I did before, not for the drugs I was doing.
I know, but so you said here though that your date, it specifies on the PSI the date of your last use of drugs. So this shows that you last used alcohol April 23rd of 2024.
Yeah, that's not good.
Okay. That you last used marijuana February of 2024. So that was in between when you got out of prison and when you got locked up again. It shows that you last used Xanax March of 2024, which is in between that 6-month time. It shows you last used ecstasy March of 2024, which is in between that time. It shows that you last used codeine in between that time, March of 2024. So it shows that you didn't just get out and have a couple drinks and maybe smoke a little marijuana. You just got out and did all this stuff. And got yourself in this position to...
The judge points out something devastating. This defendant didn't just relapse. He binged on alcohol, weed, Xanax, ecstasy, and codeine all within 6 months of release. That's not a stumble. It's a free fall. And judges sentence based on patterns, not promises.
Completely traumatize your own child. I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. And cause number 24 DCCR 1021, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1022, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. Now, here's something, Mr. Domingo, that I don't normally say.
Powerful closing words from the judge. She acknowledges he needs help, but draws a line. Prison first, self-help later. This highlights the tension in criminal justice. Rehabilitation versus punishment. And too often, the gavel tips toward punishment.
You clearly need some help. I'm not going to say that you don't. If you're going to get your life together, it's up to you to get that help. But let me explain something also. Don't talk over me, because I'm not even sure I want to say what I was about to say if you're not going to be respectful. If you can behave in prison, and I'm not saying this is going to happen, but there are things that can happen potentially where your attorney files something for me to review how you've been, and I consider probating your sentences and getting you back out of prison. But I can assure you of this. If you get to prison and act like you acted for the last 10 years when you were in prison, then you'll be there for the whole 8 years on these. That's going to be your decision. All right? I'm handing you the trial court certification in each case that shows these were agreements that I followed, so you've waived your right to appeal. I'm also handing you the written admonishment, regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Obviously, you know that information, but I'm required to read it to you. All right, you can go back with the bailiff.